People versus Silva Santos. Counsel.
Good afternoon. May it please the court, Elizabeth Vastley on behalf of appellant Mr. Juan Silva Santos. I'd like to reserve 2 minutes for rebuttal.
Yes.
This court should strike the waiver of the shock program because it was an illegal part of the sentence not authorized by statute. It permeated into the...
How is the shock waiver in this instance an illegal part of the sentence when there was no order by the court?
It was in the court's order, Your Honor. On the sentence and commitment order, it says...
Is everything in a sentencing commitment a part of the sentence?
It is, Your Honor, but in
in every instance, any notation written is a part of the sentence. Is that your argument here?
Yes, Your Honor, because the sentence and commitment order has the sentence, the length, any conditions of that sentence.
And here, what did the court order?
The court ordered waiver of shock participation, which...
Did the court order waiver, or did it give information that a waiver had been executed? Is there a difference?
It ordered the waiver because that is what it said on the sentence and commitment sheet, and it was...
It said waiver, it said shock waive, or ordered waived? Is that what you're saying?
It says waiver of shock participation on the sentence and commitment sheet. And it's also orally, the court said that as well at sentencing.
What, there are two avenues for participation in shock, is that correct?
That's correct.
The court itself can order that the defendant be able to participate, correct?
Yes, Your Honor.
And then there's another avenue that it can be directed through docs.
Yes, Your Honor.
And so are you arguing that the court both ordered, exercised its own power, that the defendant be denied shock, and then somehow prohibited docs to consider same?
So as Your Honor stated, there is court-ordered shock. And that's not really at issue here because
Okay.
the court did not order shock. What is at issue here is that the court ordered the Department of Corrections to not put Mr. Silva into the program later on. And that's where we get into territory that is illegal because the courts cannot tell the Department of Corrections what they can and can't do.
You say that because it's on the commitment.
It's on the commitment, Your Honor. It was part of the sentencing.
It's on the commitment that the waiver in fact exists.
Yes, Your Honor.
And then you say that that transposes it into an order that he not be able to participate.
That's correct, Your Honor.
Okay.
And how does your position square with corrections law, which says that shock is a privilege and not a right?
The corrections law, the directive, Your Honor?
Yeah.
So DOCS has adapted that directive in response to these waivers, but that is illegal and that's improper. DOCS is clearly responding to these orders that it's received on these sentence and commitment orders that say waiver of shock. So in response, they are conforming.
Can DOCS, irrespective of the existence of the waiver, order participation in shock if the defendant made an application?
Yes, DOCS can make its own decisions.
And was an application made here that was and thereafter denied by DOCS?
It was not, Your Honor, because of the waiver in this case. So the waiver prohibited Mr. Silva to apply for the program, and because of that, he did not apply for the program, and because of that, DOCS was unable to consider.
Prohibition by the court or the claimed waiver by him?
It's a prohibition by the court, Your Honor.
Okay.
I'm looking at 867 sub 5, where it says participation in the shock incarceration program shall be a privilege.
Yes, Your Honor. It is certainly a privilege. Not everybody gets to be in the shock program. There's a very rigorous selection process. It's a rigorous application process.
All right, so why isn't that just part of the prosecution's offer that was accepted as part of any plea bargain negotiation?
Because here it became part of the sentence, Your Honor. And because it's part of the sentence, that was improper. It has to be authorized by a statute. That's what,
Well, you
that's
say
how
it's
it works
part of the
here.
sentence, but the judge didn't sentence him not to participate in shock. The parties agreed that there was a plea offer. He was looking at an A1 or an A2, and they said, we're offering you 9 years and you don't participate in shock. Is that acceptable? And Presumably, he said yes, and that's why we're here. So you can call it that he was sentenced to it, but I think the facts demonstrate that really it was just part of a plea bargain negotiation. And isn't there value to us upholding plea bargains?
Some things are conditions of plea bargains, Your Honor, and some things are conditions of sentence, and some are both. And here, this was both. And the reason this was a problem was because of the latter, because this was a condition of the sentence. New York state law needs to authorize all sentences. We don't want judges freewheeling and making up sentences on the go. So because of that, if shock program waiver participation was proper and was a proper part of the sentence, that needed to be listed in the authorized dispositions in the penal law, and it wasn't.
I don't think our judges make up sentences as they go. I think they have the right to accept a plea bargain or not accept a plea bargain. In this case, they did. I think a judge, if somebody pleads to an indictment, can come up with a suitable plea offer. So I'm having problems reconciling your position with the authority that the judge has as well.
Judges only have the authority to sentence individuals to whatever sentences the legislature has prescribed. That's how it works here in New York.
Essentially, are you arguing that the court sentenced him to a term of incarceration and sentenced him not to participate in shock? Is that essentially what you're saying?
That's what I'm saying, Your Honor. Yes. And it would be a slippery slope, Your Honor, because if this was permitted, then prosecutors could plea bargain and judges could order no rec time, no geographic transfer requests, no work release, no good time credit. It's a slippery slope, and the line has to be drawn somewhere, and that's here.
So with regard to that, I understood, maybe I misunderstood, but I understood you'd be making an additional argument, sort of, that even if this was not a part of the sentence, but was just part of the plea, there's a public policy element, and that your argument that I thought you were making was this was against public policy because it was taking a decision that should be made by docs out of the hands of docs and into the prosecutor and defendant to some degree's hands.
Yes, Your Honor, we're also making that argument, that public policy makes this an illegal sentence, and the public policy would prohibit
Well, I guess what I
defendants-
was getting at is it might make it an illegal sentence, but it might, even if it's not part of the sentence, it might make it an illegal, unenforceable waiver.
Absolutely, Your Honor, that as well. And public policy would prohibit these waivers. This is a great program. It has reduced recidivism and saved $1.3 billion taxpayer dollars.
Do you think this program was instituted for people like this defendant who's a major drug trafficker?
Your Honor, if docs decides that they want to place Mr. Silva or anybody in the program, then that's a person that should be in the program. That decision, though, is left for docs, and here it was taken away from docs.
It's interesting that you raised that. Prior statute, only docs could put a person in shock. Court couldn't even order it. Here, the change created two avenues, and you're somehow saying that the court is encroaching on a right docs always had, just because they note the existence of a claimed waiver of participation.
Yes, Your Honor. So before the 2009 amendments, docs was the only entity that could control shock, and everybody knew that. And that's why the legislature made the 2009 amendment to allow the courts to court order shock.
Do you know if there were shock waivers before the 2009 amendment in plea agreements?
There were instances, Your Honor, where the parties tried to bargain for placement into shock, and courts found that that was illegal because the courts can't go into territory that's authorized to docs. But after the 2009 amendment...
I was asking something a little different. Before the 2009 amendment, do you know if there were instances where there was a plea agreement that included a waiver of shock?
I don't know, Your Honor. Not that I'm aware of.
I have another question in that. So before the change, when the court would write that it recommends that docs consider shock, was that likewise an ordered part of the sentence?
Recommendations are entirely different, Your Honor. So if this was merely a recommendation that the judge said, I recommend this individual not be in the shock program because of the plea bargain, then that would be permissible. What crosses the line here is the order, because that takes something out of the hands of docs, and it's always been in docs' hands. And that's why the 2009 amendment.
So did it say, I order he not participate by virtue of the waiver?
Yes.
Or did it simply note there is the existence of this waiver?
It noted that it ordered waiver of the shock program, Your Honor.
You're concluding because it's a part of the sentencing commitment that it's noted in the commitment, it becomes part of the order.
Yes, Your Honor. And before 2009, docs was the only entity that had control of shock placement. And so the legislature added one specific avenue for courts to order shock, but they didn't add an avenue for courts to take away shock. And that's because they wanted to expand the participation in this program. This program's extraordinarily beneficial. So in 2009, the legislature said, let's provide another avenue, courts ordering it. But nothing in that said that courts could take it away. And in order for that to be possible, there needs to be that authorized disposition in a statute somewhere, and there isn't. So because it isn't, that's an illegal sentence. And public policy supports this. We want docs to be making these decisions. This is their territory. This is what they observe in the individuals. It encourages good behavior while incarcerated. We have a system and a balance.
Could docs make a decision for the defendant's participation or denial if there is no application to participate?
No, Your Honor. It is initiated with an application, and that is because, of course, nobody would be forced into the shock program, and it would be more efficient to not consider applications.
And the participation in shock is dependent upon the defendant wholly embracing the requirements and what's needed in order for the benefits that you cited earlier to, in fact, work, right?
Yes, Your Honor. That's how shock works. It trades additional years of incarceration for therapy, for substance abuse counseling. It equips individuals with the tools that they need to be better situated to reenter society.
And what about the public policy of plea bargaining? Like in this case, where he's looking at life on an A1 and he gets 9 years. Is there value to that? And does that outweigh the value of a shock program?
There is to a certain extent, Your Honor, but plea bargaining can't contain illegal sentences, and that's what this is.
But
so
if
there
we
needs.
find for you, to put another spin on that, in the future, if the people are faced with this choice, they have two choices. If they really don't want this defendant in shock, A1 or, right? That's it. A1, you don't get this bargain because that may be the deal-breaking point for them, right?
We can't speculate, Your Honor, but if the
It's
prosecution.
not speculation. If I'm giving you a hypothetical. So if the prosecutor says, I think this person who's a major drug trafficker cannot get shock treatment that would be beyond the pale, and they can't waive it, so now the only way to prevent that is A1, right?
If the prosecution really has a
Then it's a
problem.
legal sentence.
If they have a problem with the shock program potentially shaving 2.5 years off of an individual's sentence, then clearly they have a problem with the program and they need to take that up with the
They have a problem
legislature.
with going from 9 years to 6.5 on this particular crime. So their choices at that point are not 9 versus 6.5, it's 9 versus, it's A1, 6.5 versus A1. You know, there's no choice for them. So in this case, should we just undo the plea?
In this case, Your Honor, part of what a sentence means is that docs is going to make some judgment calls down the road.
Should we give that
Whether
choice
that's good
back
time
then
credit.
to the plea bargaining process here? Should we put this back to where, okay, it's either A1 or, you know, that's it?
I can't speak for the prosecutors, Your Honor, but this is a program that has worked in the past, and if this is a possibility, the prosecutors should adapt their plea bargaining process to allow for that to happen.
But I guess Judge Garcia maybe is asking you about the remedy here. That is, suppose we rule your way, why isn't the right result to vacate the plea and put the parties back in their pre-plea state?
There's no automatic right to plea vacatur, Your Honor. And in this case, the proper remedy is to strike the waiver.
But why is that? I mean, the people presumably struck their bargain knowing that, or believing that they would have a benefit from this provision, right? And they, as Judge Garcia says, they might have offered something different. And maybe it wouldn't have been an A1, maybe it would have been an A2, but, right? Why shouldn't we put the parties back in their position? I understand your client doesn't want that and has asked us not to do that. And that makes me wonder whether we have a live issue here.
To answer the first part of your question, the remedy here, the prosecution has already received the benefit of their bargain because Mr. Silva's merit release date is up for this month. So conceivably, the prosecution...
Well, they've received the benefit of a bargain that they struck under the misimpression that a part of the bargain was something they could enforce. And you're asking us to take that, I mean, you know, if you bought a house and it turned out that somebody took the kitchen away, you wouldn't think that you'd gotten the benefit of your bargain.
Mr. Silva would have been eligible for the shock program in January of 2024, so that's a year ago. If this case was taking place a year ago, then perhaps it would be different. But because a year
he
has...
would have been eligible for the shock program a year ago under the sentence that he pled to, which is maybe not the sentence he would have been offered, right?
In this case, Your Honor, Mr. Silva could be released in a month under merit release. So the prosecution knew very well he could be released this early. So whether he was released, he's released from the shock program this early or from merit release this early, it's a distinction without a difference. So there's really they received the benefit of their bargain. Like I said, if this was a year ago, then maybe we would be in different territory.
All right, so what benefit does the defendant get? Let's say we reversed. So just strike that, he can now apply. And let's say they would accept him. What is he getting?
Yes, Your Honor. So his conditional release date is July 2026. So if this was struck from the sentencing commitment order, he could apply to the program, he could do the program, and he could be released before his conditional release date.
How early, do you know?
The program's 6 months, so, 6 months in advance, whenever the program starts.
Thank
But
you.
isn't that go to the Chief Judge's question still, though? Because they knew that. They knew there's a possible merit release and what the possible grounds would be for that, and they accepted that. But they didn't accept you could apply for this program, do this, and get out. So it's a different bargain. It's not the same. It's not, it just goes by the release date. Doesn't it also go by the avenues he has to attain that date?
The prosecution seems most concerned with the length here, Your Honor, of the time incarcerated. So whether he's getting released on merit or getting released...
So to accept a narrow avenue of merit is one thing, right? Okay, we accept the risk that he may be released early, and that's not what they want. But now they are accepting an additional avenue to do that, and they don't want to do that. That was part of their bargain.
It was it's a narrow avenue as well that Mr. Silva would be placed in this program by docs. But either way, they knew there was
I think the question is whether it's narrow or not. Wasn't that the terms of the bargain that they struck? And so shouldn't everybody be put back in the position they started?
No, Your Honor, because there's no automatic right to plea withdrawal. The prosecution received the benefit of their bargain because Mr. Silva didn't get out 2.5 years early. There's no world that that's happening.
So let me ask you the other
And-
part of my question then, see if we can try this. Suppose we were to decide that the remedy here would be vacator of the plea and everybody's put back into their pre-plea position. Suppose we were going to hold that, hypothetically. Is there then a live issue for us? Because your client doesn't want us to vacate the sentence in that case.
That's right.
So is there a live issue if we were to decide that?
Yes, Your Honor, because just because Mr. Silva doesn't necessarily want an affirmance or not, it would still be an important issue for this court to decide, especially given that it's...
If we were to decide that the remedy would be vacating the plea, you don't want us to vacate the plea, and the people don't want us to vacate the plea. So where's the live issue in that circumstance?
That Mr. Silva could want to do the shock program still, and an illegal waiver is preventing him from
But
the program.
that's a route available, I think, only if the plea isn't vacated, right?
That's right.
And so I'm not sure how that's responsive to the Chief Judge's question of how a live issue would remain if our view was that was appropriate, given that you say you don't want the plea vacated.
Regardless, this is an issue that's capable of repetition and evading review, and this court should nevertheless decide it. It needs to be a long enough sentence for this to be before this court. This is an example. These waivers clearly occur throughout the state of New York, and it's still an important issue.
So
that
even if it would result in vacature of your client's plea, you would have us decide it under the mootness exception, and that result would obtain?
This court should reach a conclusion on the legal issue under the mootness exception. We don't ask for plea vacature in this case, and I don't believe the prosecution is asking for that either.
But we might conclude nonetheless, I assume that it was appropriate, but I take it you're saying even if that were correct, and that was the result, you would have us decide the legal question anyway.
Yes, Your Honor. And numerous other cases, Davis, Thomas, Shanks, Bradshaw, they're cited in my reply, all have struck the waiver in
I
situations.
don't understand how we could do that. If we say the remedy is vacator of the plea, and you say, well, you should decide the issue anyway, then we go ahead and decide the issue anyway, then we're going to vacate the plea. Either we're going to vacate the plea or we're not. We're not going to say we're going to decide the issue for you, but give you a different remedy, right? So if we decide, if we were to do that, that vacator is appropriate, and you all go back and work this out in a plea negotiation under these rules, then if you don't let us do that, how do we decide the issue? Because otherwise, you're getting the benefit of the decision without taking the remedy that would come along with that decision.
Our position is that this court can strike the waiver, and that would be a proper remedy. I'll reserve the rest of my time.
Thank you.
May it please the court, Andrew Seawald for the people. Good afternoon, Your Honors.
Do you agree here that the only things the court could do is either order participation in shock or deny the right to do so as to its own power?
I'm sorry, that this court,
No,
No.
the sentencing court, when the request was made to participate in shock, in spite of the claimed waiver, the court had two avenues. The court could grant and order it or deny. Were those the only two avenues available? Or could it also then order that shock not allow him to participate?
well, I'm not sure that I completely understand the question, but I'll try to answer it. I'm sorry.
I want to make sure you understand the question. The question is, what was the power of the trial court with respect to the defendant's request to participate in shock?
Right. I believe the power of the trial court was to accept the plea bargain or not. The trial court did not have to accept the terms of the plea bargain and approve it, but so the trial court could have rejected the plea bargain as a whole and asked the
And
parties.
ordered participation, correct?
Because the defendant, one of the important things to consider in this case is that the defendant was nominally eligible for shock only because of the plea bargain in the first place. So he was charged with A1 felonies that made him ineligible for shock.
That is clear. What he said was, I did the waiver, but in spite of the waiver, would you let me participate anyway?
Right.
So you're saying, because there was a bargain, the court no longer had the power to order shock?
The court wouldn't have had the power to order shock without undoing the plea bargain as
Or letting
as
the
an
people
entirety.
out of the bargain?
I'm sorry,
Or letting the people out of the bargain?
or letting the people out of the bargain. This was a condition of the bargain, and the defendant fundamentally wants the benefit of that bargain without accepting all the conditions.
But do you agree that the court has no authority to order docs not to participate? That docs avenue of allowing participation is separate and distinct as opposed to the court ordering participation?
That's correct. When an eligible defendant makes an application to the sentencing court for participation in shock, the only decision for the court at that point is whether to say yes to the application or, by saying no, not ordering the defendant or ordering docs not to ever place the defendant in shock. All the court is doing is saying that the court is not ordering docs to place the defendant into shock.
So who is then the waiver operating on? The court, the defendant, docs?
Well, ultimately, it's operating on the defendant. He controls the process of shock application in the first place, and he agreed in this case not to apply for shock.
So if he comes back and he says, notwithstanding the waiver, I would like to be allowed to apply, you said that the court, I believe you said the court could not do that unless, I suppose people could consent or the people would be allowed the opportunity of vacature of the plea. So does the waiver then strip the court of authority to allow the defendant to participate in shock?
I suppose, yes, as a part of the entire plea bargain.
That's what I mean, yeah.
Yes, so the court was in the position of approving the entire plea bargain or not. And I would note that the defendant never claimed, when he raised the possibility of shock, he said, I'd like shock or some other program. And when he raised that possibility, the court said that, well, I can't give that to you because it's not part of the plea bargain. The people, or it would be contrary to the plea bargain.
What do you say with respect to the claim that by notating the waiver on the judgment of conviction, that the court ordered that he not be able to participate, that shock couldn't let him participate?
Well, I would just point out that the commitment papers themselves, there's a place for the court to check a box that would have said shock incarceration ordered. The court didn't check that box, obviously. At the bottom of the commitment papers, and this is at the appellant's appendix at page 3, there's a space under the word remarks where the court printed waiver of shock program participation. So the court noted that in the commitment papers, but
Why would a court note that in the commitment papers? Because I want to get back to the question you got a little while ago about who is this agreement operative on? And I heard you say earlier that the options available to the court when it was presented with a plea bargain that included a waiver was either to accept the plea bargain or reject the plea bargain, but not to pick it apart. You don't get a line item veto on a plea bargain. But my question really is, would that waiver then operate on docs? To the extent that, if the answer is no, that the defendant could apply for shock at docs, notwithstanding the waiver in the plea bargain.
well, I think the ultimate question is, we don't really know what docs would do with this waiver, because the defendant never applied.
So that's a different case.
So that would be a different case. If the defendant had applied.
What's your position as to whether docs could grant a waiver, could grant him permission to participate in that circumstance?
I don't really know, Your Honor.
Well,
I don't-
wait a
I don't
minute.
know.
Wait, wait, wait.
I mean, I think what we're asking you about is, what's the scope of the waiver in your view? I'm not asking you to opine on what you think docs might or might do, but does the waiver, as you understand it, prohibit docs from allowing him to participate if he went and applied? And if he did go and apply, and your view is that the waiver operates on the defendant, and the defendant then is acting in violation of the terms of the waiver, then what next?
Well, we do know that docs, by its own internal directive, does honor the waivers that are, this type of waiver that's entered as part of a plea bargain.
So they bind themselves to the waiver that's contained in the bargain.
Yes, part of their yes.
And if the defendant nonetheless applied to participate to docs, what, in your view, would the consequence be, if any? If the defendant has waived the right to do that, but nonetheless applies?
Well, the question would be whether docs would then uphold, would actually honor the waiver, what they would do with the defendant's application as a whole.
Right.
And we don't really know that in this case, obviously, not only because.
So do you agree that docs, independent of the plea bargaining process, has their own power to accept or reject participation if an application is made?
Yeah, I think the key words there were if an application is made. And obviously here, an application was never made.
Wait, so you think that, you think that docs has the ability to disregard the plea waiver? Legal ability?
Your Honor, I'm uncomfortable giving a
Well,
commit.
let me try it this way. I mean, you're bargained for these things, you want them, and so that's because you believe that docs will honor them, not that docs will disregard them, no?
Of course. And so
And
the
presumably, if docs took an adverse position, you would run in there and say, wait a minute, this guy's got a plea waiver.
the expectation of the
Shock waiver.
people, of course, in this case, was that the
Well,
waiver
not just
would
in this
be-
case,
would
in
be
any,
honored.
I mean, this is not the only case where you've asked for a shock waiver, fair?
That's correct.
And all the time that you ask for it, you're expecting it's going to be enforced, otherwise it wouldn't have any value to you.
That's correct.
Okay.
That's correct. And
But what would be your recourse if they didn't?
if they didn't, then that would change the plea bargaining posture in any case like this.
I understand for the future that that might affect the policies in your office, I get that. But I'm asking, let's say he had applied, they think he's an appropriate candidate, they accept him. Would you have any recourse under those circumstances?
I'm not sure. I'm not sure whether they would ask for the view of the
Let's say they
prosecutor's
did, you
office.
give them the view, and they say, well, we're not persuaded. Do you have any recourse?
I don't think so. I don't know.
Can you ask for the plea back? I mean, is the application itself a violation of the plea?
I suppose that's true. If the defendant is waiving his right to apply for shock, and then goes ahead and does that anyway, I don't know if, I think we'd have to find out what docs would actually do with that application. In this
It
particular
isn't what they
case.
do with it, it's the act of asking for it that's the violation, isn't it?
Sure, yes, that would be in violation of the plea
Well,
agreement.
that would suggest to me then that the waiver has absolutely nothing to do with the sentence. Wouldn't you agree?
Right, I think, yes, that it's an agreement that the defendant entered into as part of the plea bargain, and the court noted it in the sentencing order, but I would agree,
Exists
yes.
independently of the sentence. If you could go back to court and say, hey, he waived this and now he's applying for docs, he's applying for the shock program at docs, it's really got nothing to do with the sentence at all.
But I take it you're saying, though, that you could enforce it by way of seeking vacatur of the plea because the defendant violated it. So to that extent, it seems like it is enforceable, no?
Right, I suppose that would be correct, Your Honor, that we could go back to the trial court and argue that he
And
violated the plea agreement.
if we were to disagree with you, what's your position on what the appropriate remedy would be? Would it be vacatur of the plea or no?
I believe the appropriate remedy would be vacatur of
And
the
that
plea.
would be what you would seek in that event? What you would ask us to do?
Yes, we would ask that the case be remanded back to the plea court, where, yes, because I think
Can I just
fundamentally.
clarify, just to clarify, I'm sorry, was the waiver not to apply to the court either? I mean, it clearly is, don't apply to docs. Was it also don't apply to the court either?
The waiver was to not apply for shock, and it didn't specify whether to apply to the court or to apply to
So
docs.
then it's ambiguous and unenforceable, or do you have a position on whether or not it applied to the court?
I would note that in the defendant's reply brief, they try to draw a distinction between docs ordered shock incarceration and judicial ordered shock incarceration. And they concede that judicial ordered shock incarceration is waivable. And so, but I would submit that the question is that's splitting a hair that shouldn't be split. The question is whether a defendant can waive his own right to apply for shock.
Well, did he
under either
apply here
avenue.
to the court?
I'm sorry?
He applied here to the court, yeah?
I
Yes?
don't know if
Yeah.
if what he said at sentencing should be
Okay,
considered an
let's
application.
assume, let's get the hypothetical that someone signs this waiver, doesn't say if it's the court and/or docs, they apply to the court, and if the court had complied with the request, granted the request, right, would not the ADA seek to withdraw the offer?
Right, I think the answer.
So that would be because the ADA thinks that the court is bound, right?
Well, because the parties had reached an agreement about what the overall sentencing
Yeah.
parameters should be.
But if they had requested and the court didn't grant it because they felt bound, I assume you wouldn't say, oh, they breached it by just asking you. Right? Because what you care about is whether or not the individual actually gets to participate in shock.
I think that what would be fair to say, I can't speak for the motivations of the individual prosecutor who is handling this case, and I would note that this was a
Oh, well, I thought
special-
that was clear from your briefing. Then I misunderstood your briefing.
What
I
I-
thought your argument in the briefing was that you wanted this person to serve 9 years. Did I misunderstand the
No,
briefing?
not at all. That's correct, Your Honor.
That's correct, but you already know that he might not serve 9 years, regardless of shock,
That's true.
right?
That is true.
You have no
but
control over that.
That's true. But I think what
Does that really, in that way, you can't say that this is the sine qua non of this agreement was that the prosecutors in that office absolutely needed him to serve 9 years.
But what we knew for sure was that if he applied for shock and was put in shock, that would have the near certainty of reducing his effective sentence by 2.5 years. And what we know is that the overall sentencing, the overall sentence that the defendant would serve, even allowing for the provisions that apply to every defendant and every inmate, that the people and the defendant and ultimately the court that approved the plea were all satisfied that a 9-year sentence was an appropriate plea bargain, an appropriate sentence for what was an incredibly
With
serious
an understanding
case.
that he might never serve 9.
Yes, I mean, that
Regardless of
understanding
shock,
is
regardless of
built,
shock.
I think that understanding is built into every sentence. Everyone knows going into the sentence, when we negotiate a sentence, what the defendant in that case
In other
will
words,
actually end up serving.
There might be other avenues that would result in him serving less time, but not the avenue of shock participation.
Exactly. That's exactly right, Your Honor. And in this case.
So if I'm just understanding this a little bit clearer, as a policy matter, I mean, your office would decide whatever it wants to do. If indeed we were to agree with them that you can't enter these waivers, you can't require these waivers for the plea, the reality is you enter pleas not knowing that you're going to get the full time anyway. So shock is just one of these other types of avenues that might reduce the period of time.
I would say it's different from some of those other avenues. It's not just one of the many avenues. It's different in a few different ways. Number one, it's triggered by the defendant's application, whether to the court or to docs. Number two, the statute describing shock specifically describes it as a privilege. And in that sense, it's different from early release and from other considerations. Number three, I would note that things like early release, one of the primary purposes for early release is for docs to, is that it's a tool for docs to help manage discipline and order within the prison. Being able to give time off for good behavior is something that is important to docs. And I would note that in the Washington State Supreme Court case that my adversary cites in its reply brief, where the Washington court said that you couldn't negotiate, or the court couldn't order as part of a sentence that the defendant give up the right to early release, it was that orderliness function or purpose that the court recognized in early release. So that's different from shock incarceration. That's not the shock incarceration has a different rationale than early release and some of these other programs. And I would just point out also that docs itself obviously does not regard a waiver of shock as an encroachment upon its own authority and its own ability to manage the orderliness of its facilities, because they have stated that they will honor these waivers. So I think that's very telling in a claim where in a case where the defendant's primary claim is that the waiver of shock was itself was illegal, was invalid because of some separation of powers issue, that it encroaches on the authority of docs. Even docs does not regard it as an encroachment upon its own authority. So in this case, where this was a knowing, voluntary part of a plea bargain that was extremely beneficial to the defendant, where for possession of over 50 pounds of heroin and fentanyl, millions of dollars in drug transactions, this defendant was able to obtain a sentence of 9 years rather than the 15 to life that he faced. I would ask the court in this case to uphold the validity of the waiver. Thank you very much.
We have a system here in New York that when individuals are sentenced, after the sentencing, docs then takes control of programming, of good time credit, work release, and the shock program.
Because the court commits the defendant to the custody of docs.
Yes, Your
They
Honor.
have control over everything at that point.
Yes, Your Honor. And if the prosecution really takes such issue with the possibility that docs, after a very rigorous assessment of the welfare of the community and the applicant and community safety, thinks this defendant should be in the program, then they have a problem with the shock program. And they should take that up with the legislature and
They may
petition.
just have a concern about the length of the sentence, not the quality or efficacy of the program.
But that is shock, Your Honor. It's the balance between the length of the sentence in exchange for a very rigorous
I mean, in this
workout
particular,
therapy.
I mean, in this particular case, they may have been looking at what the bottom line number was, seems to me.
Yes, Your Honor, but docs also considers this particular case. They consider the facts of the case. They consider the crime. They consider everything.
In striking the plea bargain in the first instance.
Sorry, Your Honor?
I mean, in striking the plea bargain in the first instance, that may have been what was motivating the concern with shock.
Yes, Your Honor. Docs ultimately will make that judgment call, and the prosecution just has to defer to docs at that point.
It's clear that applying to docs violates the waiver, right? I mean, it's clear.
Yes.
So they made this deal based on this waiver. You're saying we should be able to apply anyway, and you can apply, but then they can come in and say you violated the terms of your plea agreement, because you have violated the terms of your plea agreement. So
Yes.
why don't they get the bargain back?
And violating the terms of the sentencing commitment sheet. Yes,
No, you
yes, Your Honor,
violated the terms
traditionally.
of the waiver. I mean, this waiver was part of the agreement that they struck, and you violated it by applying to docs, and they should be able to go in and say, we didn't get the benefit of our bargain, we want the deal back.
Yes, Your Honor. Traditionally, in cases, the remedy could be plea withdrawal, but there's no automatic right to plea withdrawal. And here, under these facts, it's just not necessary to cure the error. The court can just strike the waiver, and that can cure the error. And especially
Well,
here.
your adversary has just told us that they think the appropriate remedy would be vacature of the plea. I don't think told us that that was required, but that that was what they think would be appropriate. So why would it not be appropriate here?
The prosecution is not asking for plea withdrawal. They're asking for a remand for the possibility of plea withdrawal. They're not asking for it right now.
And in your view, even that would not be appropriate?
No, Your Honor.
And why is that?
Because this court can cure the error by striking the illegal waiver, which has happened in other cases, as cited as my
See,
report.
that, if you think of this as a sort of contracting matter, and to me, as a commercial lawyer, that would make some sense if the benefit they lost was small in comparison to, what they got. But this is a 9-year sentence and a 2.5-year reduction, which is a pretty big chunk of what they got. So, thinking of it that way, I would think, it seems like putting the parties back in their bargaining positions. If this, made a month difference out of a 9-year sentence, maybe you're right.
Absolutely, Your Honor, and that goes back to the argument I was making, where this actually isn't 2.5 years in this particular case, because 2.5 years ago was last July. Here,
But it was when the plea was made. You're
Yes.
looking backwards at it. At the time when they were asking for that waiver and your client agreed to it, right? It was in a very different posture than it is right now, looking backwards.
Yes, Your Honor, but at this point, when we analyze whether the prosecution received the benefit of their bargain or not, the earliest Mr. Silva would be getting out would be a year in advance of his CR date, conceivably based on shock program participation. So it's not 2.5 years. So when Judge Wilson was talking about, big or small values relative to the length of the sentence, it's really only the issue of an extra year, which would have this very rigorous and strenuous program that's been proven to reduce recidivism and help substance abuse.
And the people might love that program for other defendants. They just don't want it for this defendant. And in fact, the legislature said that A1s and A2s are exempt from it. So they're saying, we're following what the legislature said. We don't want him to have shock, but we'll give you the benefit of a 9-year sentence. I don't understand why it has to be, then forget the shock program. They might love the shock program for any number of defendants. It might actually be an excellent program.
In this case, it's really that docs may consider the defendant for the program, and that the prosecution just needs to let that happen if that's what docs wants. They can't micromanage every single aspect of the incarceratory experience.
But the point is not that, I think. The point is that there was an agreement as a part of the plea bargain not to apply.
Yes.
Not a question of whether there's some micromanaging of docs' implementation of the program.
Yes, Your Honor. And in this case, this isn't 3 years before Mr. Silva is getting released. So it's not that type of benefits, pure sentence-wise from the program. I see I'm out of time if there are no further questions.
Thank you.